Secretarians, guests, it's my honor to welcome Richard Altman, better known as Dick. Dick is the magistrate for all the divisions of the Fulton County, Ohio Court of Common Pleas and the Henry County Court of Common Pleas, having served in that position since 2005. Prior to this, he serves as a mediation coordinator of the Northwest Ohio Court of Mediation Services for 6 years and as a trial lawyer for 18 years. He has worked extensively as an attorney and a mediator in the areas of civil law, domestic relations, parenting issues, and criminal matters. Dick is a frequent presenter for organizations such as the Ohio Supreme Court, the Ohio Judicial College, the Wisconsin Association of Mediators, the Association of Family and Conciliation Courts, and the American Bar Association. Dick currently serves as the chairman of the Ohio Supreme Court Commission on Dispute Resolutions and serves as the planning committee for judicial education. He was the recipient of the 2013 Ohio Association of Magistrates Education Award. Magistrate Altman served on the board of directors for the Association of Family and Reconciliation Court from 2004 through 2017, serving as the board president from 2014-15. Dick's a member of the American Bar Association, the Ohio State Bar Association, the Association of Family and Conciliation Courts, and as a member of several local bar associations. He received his bachelor's degree, summa cum laude, no less, in 1979, and his Juris Doctorate degree, cum laude, in 82, from both the University of Toledo, where he was valedictorian of his respective graduation class. In addition, he studied at the University of Sydney Law School, Sydney, Australia, in 1981, as the recipient of a Paul Harris from Rotary International. And he explained to me that was at the urging of Raleigh Doden. In addition to his duties as magistrate, Dick teaches at Owens Community College Police Officer Training Academy and provides continuing education programs to the law enforcement officers throughout Northwest Ohio. Dick was a Hicksville Rotarian, and we figure like maybe 1988 to maybe 1995-6 in there somewhere before he was called away to Fulton County and couldn't get back for it. So let's give a big Rotary welcome to Dick Altman.
Thank you, Pat.
You're welcome.
It is a pleasure to be here. I think the last time I was here, I paid a fine too, so things don't change. And you know, I have to say, the cordiality and the fellowship of this club really hasn't changed, which is pretty impressive. Over the years, I've talked to several Rotary clubs, including many in Australia, and I don't see a lot of that fellowship. You guys have really done a nice job of, guys and gals now, have done a really nice job of staying together and doing things for the community. It's very impressive. It was at Raleigh Doden's request that I applied for that Paul Harris Fellowship. And it really wasn't much of a request in Raleigh. I was told I was going to apply for that fellowship. But it was a great experience. I spent my second year of law school at Sydney, Australia. It was truly interesting. I came back, people would say, "Where are you from?" as I would say good day to them. I had quite the accent when I came back, kind of a combination of Midwestern United States and Australia. But it was a great experience. I truly enjoyed it. How many of you know what a magistrate is? Anybody? A couple? Okay, well, you better know, Michael. Michael has appeared in front of me on a number of occasions, always as a lawyer, by the way, never as a litigant. And I will tell you that we have what we call guardian ad litems, who are attorneys generally who are appointed to serve the best interest of children in parentage cases or divorce cases. And you have sitting with you probably one of the finest guardian ad litems of Northwestern Ohio. So he's truly a good guy, and he's a heck of a good lawyer, so it's nice to see him here. So magistrates are basically non-elected judges. We have very broad powers in Ohio. I can do everything the judges can do at the common pleas level, except I don't sit in final judgment on felony cases. So if it's a civil case, and I do a ton of civil cases, I handle it from the very first status conference through the jury trial or through some type of decision on it, whether it's summary judgment or otherwise. Juvenile cases, I handle them from beginning to end, including disposition, whether that disposition is a sentence to the Department of Youth Services or a local time or a juvenile rehabilitation unit. Domestic relations cases, we handle everything. We can do temporary orders, we can do final divorce hearings. So I really never know what my day is going to look like. Because I serve all the various different jurisdictions, in one day I might be doing child support, I might go do a motion to suppress in a felony case, and the next thing I know I'm doing a juvenile case, and then I follow it up at the end of the day with a divorce. So I get to see a wide range of things. Right now in Ohio, there are more serving magistrates than there are serving judges. Now there's a real reason for this, and it's called finances. So judges can only be placed, new judges only get to occur if the House and the Senate in Ohio and then the governor approve that. They are paid for out of state money. We are paid for out of county money. You can guess who wins that argument, right? So when there's a need for a new judicial officer, it usually ends up being a magistrate. People have a right to appeal my decisions just as they would a judge, and it's pretty much a free shot, so almost everybody takes that appeal for us. The appeal is directly to the court that we sit in, and then from there up to the Court of Appeals. It's a good experience. I spend most of my day trying to resolve cases. I try to use the mediation skills that I had, I hope, to do that, whether it's a civil case or a domestic case, and try to get people to resolution. But there are a lot of other ways for people to resolve their cases now in Northwestern Ohio. I don't know how many of you have been a litigant in Northwestern Ohio since 1998, but you are truly, I think, blessed in Northwestern Ohio. Because in 1998, we were granted a grant from the Ohio Supreme Court, and we became one of 10 areas that started what we call the institutionalization of mediation in the Ohio courts. It was a big push from Chief Justice Moyer, who felt that mediation was a better way for people to solve disputes. They gave us this grant, and we were the only multi-county program. We actually started out with two. It was Defiance and Henry counties. Fulton County very quickly joined, then Williams, then Paulding and Putnam. So it now covers 6 counties. It has been ongoing since 1998, and we've been pretty much a leader in Northwestern Ohio. How many of you are familiar with the process of mediation? Anybody? Some? Okay. Mediation is a really good tool. Parties who are in dispute sit down with a third-party neutral known as a mediator. That mediator will try to facilitate a discussion between them and assist them in reaching a resolution. The process can be difficult, it can be arduous, it can almost be volatile at times. But what we have found over the years is that when people reach their own resolution, if they're able to come to an agreement that they're satisfied and will live with, especially as it relates to minor children, that agreement is going to be a longer lasting agreement. It will have a better chance of being successful than something that I hand down. So if parties don't reach an agreement in mediation, they can always come back and see me and I will make a decision for them. But as you can imagine, in a trial, I generally get maybe, in a domestic relations case, I will maybe get 2 hours of testimony, fair bet, Michael, on parentage issues. 2 hours. So in that 2-hour time, you have to give me enough information that I can decide who's going to be the residential parent, how often that other person is going to get to see that child, who's going to be responsible for the educational decisions of that child, who's going to be responsible for the extracurricular activities of the child, who's going to take care of making medical decisions for the child, how much child support is going to be paid and by whom, and who's going to be responsible for medical insurance, and what are we going to do for uninsured medical expenses. That's not an easy task when you're given 2 hours worth of testimony. I want you all just for a second to think about your children, and could you provide me enough information in 2 hours to have me make those kind of important decisions for you? Pretty darn tough, right? On the other hand, in mediation, the 2 parties are sitting there, they've got all that information. They have all the information that's necessary for them to make a good decision. And that's the reason that those agreements carry through. I hand down an order, people don't have a whole lot of choice. They either abide by it, or they potentially face contempt of court. I don't like it when people don't follow my orders. So we enforce them, right? On the other hand, they aren't going to like them very long, and they're going to come back, and I'm going to have another motion to change the parental rights and responsibilities file. And what we have are what we call frequent filers, as opposed to frequent flyers. People who constantly come back to court because they just can't quit. It's not good for children. And what we've found over the years is that mediation has really given us that opportunity to reach resolution of cases. The parents are happy. They last a long time generally. What we've actually found is those agreements will last until something major happens in the child's life. If they're really young children, maybe when they start school, we need to make some modifications. If they're teenagers and they get to be 15, 16, or 17, they want some changes, because going to one house every other weekend is really not that cool. If dad lives in Toledo and mom lives in Hicksville, kids don't like leaving their friends every other weekend for a full weekend. So sometimes those things modify what we were doing. People who go through mediation and who have been successful tend not to have to come back to us. They will sit down together and find a way to reach that resolution, or they'll go to another mediator or come back and ask us to go to the mediator, and they'll reach a resolution. So from that perspective, we've been really fortunate in Northwest Ohio. We use it, by the way, not for just domestic relations cases. I joked with some people one time when I was speaking that they asked me what kind of cases I mediated, and I literally mediated everything. One particular day, though, in Henry County, I mediated a bad hay case. Now, in case any of you didn't know it, I know there's some farmers in the room who do know this. If you bale hay that has cow manure in it, it's really not going to last very long, and it's not going to be very nutritious for the animals that eat it. And that's what had happened. The guy had baled hay. Actually, I think it had horse manure in it. So that's what I mediated in the morning. I mediated a resolution of that. I left that mediation. I drove to Williams County, where we mediated the settlement of a wrongful death case. An elderly lady had missed a stop sign, killed a younger person. So my first case settled for about $300 that day. My last case of the day settled for $2.5 million. So we mediated kind of a range of cases, you might say, when it came to civil issues. And our mediation program still does that. The worst case I ever mediated involved a log chain. And I knew I was in trouble when the gentleman said, there is not a prettier picture than my pickup hooked to my log chain and pulling another pickup out of the ditch. You are not going to settle that case. Unfortunately, and the other guy took his log chain and didn't return it. And they didn't settle it. They went to trial, and the guy got exactly what I told him he was going to get, $15 for his log chain. So that does happen. Mediation, though, is not the only alternative we now have for litigants in Northwest Ohio. We have a program that we call Early Neutral Evaluation. Years ago, I think it was about 1999, I was at an Association of Family and Conciliation Court conference And I was talking to a gentleman by the name of Denelden Dennis, who was in Hennepin County, Minnesota, which is Minneapolis, Minnesota. Hennepin County at the time was considered to be on the forefront of dispute resolution as it related to parentage issues. And I got the opportunity to know Denelden, and I asked him if I could sit down and talk to him about this program that I heard about called Early Neutral Evaluation. And the process works like this. They would take one mental health professional and one attorney, a male and a female, and they were a team. And when parents were in a dispute, they would bring the parents and the attorneys in, they would sit down with this team, and they would present to the team what they thought was going to be their best case scenario if the matter went to trial. And they would lay it all out on the table. After that was finished, those evaluators would go back in and they would meet and they would talk, and they would come out and they would propose what they think the court's going to do with the party's case. I thought about that for a long time. I thought, well, this can work, but we don't have a lot of mental health professionals running around in Northwestern Ohio, if you don't know that. Actually, very few. It's the one area where we really lack. So we use teams of attorneys, guys like Michael and female lawyers, who could come in, and we'd always create, if it was a male and female litigant, we had a male and a female team. If we had two female litigants, we had two females. If it was two males, we had two males. We do, by the way, have gay divorces in Ohio, and we do have gay marriages in Ohio, and we've had to use these scenarios. And we would have the same process. We would use the same process. It worked very well. The litigants have three options. They present their case. The evaluators give what they believe will be the resolution. The parties can say, man, that makes complete sense. We're good, we're done, we'll accept it, case settled. Or they can say, you know, I don't think so, Dick, and we're going to go to trial. If they select that option, I never know what happened. When they come in front of me, the only thing I know is that there was an ENE. I don't know what was proposed as a resolution. I don't know who said what. I don't even know who the evaluators were. And I have a trial that's blind as to any potential resolution. The third option is they can negotiate from that proposed resolution. Now, Hennepin County did not do this, but we thought it would be beneficial if one of our evaluators would also be a trained mediator. So the way our program works is we always tie a trained mediator with the other evaluator. So if the parties say, you know what, we're not quite there yet, I'm not sure that's quite the resolution, but it's close, we can then have that mediator step in and work with the parties and try to reach resolution. We do it not only in domestic relations cases, but we've done it in civil cases. Where we found it, and where we seem to be finding that it works the best, is business cases, contract cases between two business parties who are going at it. It also works very well in personal injury cases. It works very well in construction cases. Construction cases are the worst to try if you're an attorney, because everybody knows how to construct something, especially when they've never constructed anything. So it really gives a good opportunity for parties to present their case, kind of get their day in court without the expense of being in the courtroom. So that's been extremely successful for us. The success rate on those cases, when we were doing them constantly, we've lost some of our grant money, so we're not doing as many now, but the success rate was up above 75%, which when you can settle a case at that level, you're being pretty effective. Next tool that we've got is, I've got till what? About another 5 minutes?
Yeah.
5 minutes? 5?
Questions and answers.
Okay.
Yeah.
I'll give you one last tool that we use, and that's called parenting coordination. So parenting coordination, those frequent filers that we talked about, they fight over the least little thing. People, I'm not kidding you, I've had motions to show cause because father had hair cut. I had motions to show cause because somebody enrolled them in swimming lessons and I was going to enroll in swimming lessons. Fighting about where baseball is going to be played, Antwerp or Hicksville. I always tell people, I decide the baseball case in November. Now, if you haven't figured that out, it's after the baseball season, because I find it disgusting parents can't work this out. So what we do is we've got a rule of superintendents that we were able to get through the Dispute Resolution Commission and through the justices at the court, where we can appoint a person who is trained as a mediator, they're trained as a lawyer, and they are trained as an arbitrator, and they are assigned to a particular family. So if that family has an issue that comes up, where they're going to have swimming lessons, who's going to cut the hair, who's going to pay what medical bills are really owed, rather than having to run back to the court, they go directly to their coordinator. They don't need to go out and hire counsel to do this. They sit down with the parenting coordinator, and that parenting coordinator will try to negotiate a resolution. If they're successful, done. If they're unsuccessful, that parenting coordinator becomes an arbitrator. And they say, okay, any more information that I need to have? No, this is the decision. And they announce and then write a decision. If the parties don't like that decision, they can appeal that decision to me. However, if you appeal that decision to me and you lose, you're paying the other side's attorney fees. So there's a real benefit there. It keeps the frivolous stuff from happening. We have also now developed a process called elder care coordination that is very similar to parenting coordination. As I look around the room, many of us are now over 50 years of age, and many of us are going to have families that are going to get in arguments the older we get. As a way to avoid some of those problems for the probate court, we're going to use a very similar process where a person will be trained in handling elder issues. They will meet with the family, they will help the family negotiate. When they can't reach a resolution, they will make recommendations to the family as to what should happen. So far, all the information seems to be that it's been very successful. So I don't want to take up any more of your time in case you do have any questions. It is an absolute pleasure to see all of you again today. I never make it into town, so I never get to see most of you, and it's a shame that I don't. I miss many of you, so. Any questions at all? Yes?
Yes. Could you draw the distinction between arbitration and mediation again, please?
Sure. In arbitration, the third party neutral is going to make a decision for the parties. Arbitration is litigation without a judge or a magistrate sitting there. In mediation, the mediator will make no decisions. Only the parties can make a decision. Now, the mediator may propose some resolutions, but the mediator can't say this is what you're going to do.
Thank you.
Yeah, no problem. Any other questions at all? Thank you all very much.